Well, it is here. What am I talking about? I'm talking about the United States Supreme Court decided, of course, the Rahimi decision where they ruled against the Second Amendment broadly. There's been a lot of controversy, a lot of discussion, different people taking different positions of this isn't so bad and other people saying that the sky is falling. Well, we now have the Ninth Circuit Court of Appeals in U.S. versus Maney, the case under discussion today, which was deciding issues surrounding the 4473 background check as part of a purchase for firearms, and more specifically looking at straw purchase and making false statements on these forms. The relevance, aside from that in and of itself being important, is we get to see how the courts are going to start to tease and pull apart the Rahimi decision, whether for or against the Second Amendment. Guys, we're talking Ninth Circuit, we're talking straw purchases, 4473, Bruen and Rahimi. Let's get into it. All right, so first some facts, and this is going to be light and fast. We're talking about Miss Gail Maney, or Maney, I'm just going to say Maney, apologies on any mispronunciation, who basically purchased her first gun, then later on in that same week went back to the same store in Reno to purchase 7 more handguns. Now, I don't know if she was purchasing 7 firearms are all identical to one another, if they were identical to the first gun purchased, don't have those details. Frankly, those details don't really matter so much for our discussion. The bottom line is that the FFL flagged this as being suspicious, not in and of itself that she purchased 8 handguns in the same week, but because, among other things, while she was making this purchase, she's taking pictures, she's on her phone a lot, and these are all going to be signs and symptoms of somebody who could be making a straw purchase for a prohibited possessor. They contacted the ATF. ATF sent an agent. They set up a time for her to come in and pick up these firearms. Some sort of delayed transaction obviously going on here. So she shows up to pick up the 7 handguns, meets the agent while walking out of the store, having paid, handguns in hand. She consents to go to the ATF office, and at that office, after giving an interview where she denies any wrongdoing, she strangely, though from my background as ex-state prosecutor as well as a defense attorney, predictably allows them to search her phone. And of course, we all know what's found next, right? They find a whole bunch of messages between her and her son, who just so happens to be a felon, surrounding what handguns to buy and all that other kind of stuff. Again, I don't have a tremendous amount of details. Frankly, those details don't really matter because that's not exactly what we're focused on. Her case ultimately winds up going to jury trial. She is charged in federal court for violation of 18 U.S.C. section 922 sub A sub 6. That's the violation of the 4473 because she made a materially false statement on that form, presumably that she's not purchasing it on behalf of someone else who may or may not be a prohibited possessor. So that's how she winds up finding herself in criminal court. She takes her case to jury trial, loses, and appeals. It is that appeal that we are focused on here. And if any of you are wondering why we're not focused on those details, 2 things. A, I don't have them. And B, the defense evidently didn't want to raise some sort of not guilty withstanding the verdict or insufficient evidence to convict, and however it is that you phrase this in this particular jurisdiction, but there are ways that defense attorneys on appeal can challenge a conviction through trial, basically saying that there's no reasonable way that the jury should have reached a conviction. We're not talking about that. They didn't challenge it. That's the reason why we're not talking about it. So we're in the Ninth Circuit Court of Appeals. That's the West Coast, some call it the Left Coast Court of Appeals. Keep in mind that the Circuit Courts of Appeals, there's 13 of them, sit over and above the 94 federal district trial courts. So we went from federal trial court up to the 13th, one of the 13 circuit courts, and then the only thing above that is the United States Supreme Court. So the specific legal discussion here is whether or not the government can constitutionally impose upon you, in other words, it's not a violation of the Second Amendment, to have the 4473 and the need to be truthful on that 4473. That's really the direction that we're going here. And more specifically, we're really talking about whether or not, I guess in essence, you're allowed to lie on that 4473. At least that's how the Ninth Circuit starts to set it up. I'm just going to tell you right here, right now, they're going to affirm this conviction. If you didn't know that was coming when I used the words Ninth Circuit Court of Appeals, well, I'm sorry for the spoiler, but Generally, when you hear that term, Ninth Circuit Court of Appeals, you can usually, not all the time, but usually expect an anti-gun outcome. So here's how they start to set it up. And this one comes from the United States Rahimi decision, which we've covered elsewhere. The Supreme Court says in Rahimi, quote, "When a restraining order contains a finding that an individual poses a credible threat to the physical safety of an intimate partner, that individual may, consistent with the Second Amendment, be banned from possessing firearms while the order is in effect." End quote. I want to be emphatically clear. That is not me who is putting forward that suggestion. That is the United States Supreme Court. I am merely the messenger on that. Be sure to hang around until the end because I'm going to be getting into three massive positives, three big wins that are actually tucked within this decision that would have been unimaginable 5 years ago. Three things even the Ninth Circuit Court of Appeals is forced to agree to and admit. Don't forget to hit that like button. And my question for you in the discussion section down below is, how much worse do you think things might get drawing from all the different things we're looking at here? And how important are those positives? How important are those victories that even the Ninth Circuit is forced to concede that I'm going to be covering towards the end of this video? Now back at it. So they're setting up the fact that individuals are allowed to be barred from possessing firearms consistent with the Second Amendment according to the Rahimi case in the United States Supreme Court. The Ninth Circuit goes on to note that it is important to remember, quote, "like most rights, the right secured by the Second Amendment is not unlimited," end quote. And if you don't like the Ninth Circuit saying that, well, your real beef is going to be with the United States Supreme Court. And that's part of the Scalia decision from 2008, that's Heller at page 626. Like most rights, the right secured by the Second Amendment is not unlimited. So even Scalia allowed for the fact that there's going to be limits and restraints on the Second Amendment. Again, I'm only the messenger when I say this, all right? The question is, with that in mind, what are those limits? Because I'm sure that anti-gun groups and individuals like myself who are pro-liberty, pro-firearms, would, well, disagree sharply about what those limits might be. The Ninth Circuit goes on in this decision, linked in the description box below, to cite Justice Kavanaugh, that's a Trump appointee, who emphasized this point in his concurrence as part of Bruen. So this was a separate concurring decision, so it's not legally binding, but it can be instructive to show how different judges think about things. Justice Kavanaugh in the Bruen decision wrote, quote, "The Second Amendment is neither a regulatory straitjacket nor a regulatory blank check. Properly interpreted, the Second Amendment allows a variety of gun regulations," end quote. And he said this citing to the Bruen decision at page 597. So I'm not asking you to like this, but I'm telling you that the Supreme Court has set out the fact that there is going to be a lane for regulations. And again, I'm not telling you to like this. I'm not asking you to like this. I'm simply telling you from an educating perspective, here's where we're at. And the Ninth Circuit continued to emphasize this when quoting Rahimi. Again, Justice Kavanaugh discussed the ongoing validity of traditional exceptions to the right, such as longstanding laws imposing conditions and qualifications on the commercial sale of arms are presumptively constitutional. So again, some quotes to deal with there. So if you're like me and if you heard all that, you think that the Ninth Circuit Court of Appeals is going to basically say something like this: hey, this is going to be constitutionally allowed under the Second Amendment because the Supreme Court has said all these things. But instead they pull a little bit of a Charlie Brown. So if it sounds like to you, like it did to me when I was reading this decision, that, oh, they are going to find that all this is going to be permissible under the Second Amendment because it's part of the Second Amendment that you can have these reasonable commercial regulations, yada, yada, yada. You're wrong. That's not how they get there exactly. Instead, they kind of set you up for that, and then they Charlie Brown you by pulling the football and instead basically saying, look, this section that Miss Maney was convicted under, section 922 sub A sub 6, really prohibits making false statements. And false statements really have nothing to do with possessing firearms. And therefore, the whole defense, the whole issue here in appeals that she has this right from the Second Amendment that is being violated by 922 sub A sub 6. And, this just has nothing to do with the Second Amendment. I've got a quote from the court that's kind of boring to read. I've attached it in the description box below. So you can see how they kind of set you up for saying, yeah, it's really okay as part of the Second Amendment. And then instead they pull the football away by saying, look, none of this has anything to do with the Second Amendment because we're talking about making a materially false statement under this particular section.
That just makes no sense. I mean, it's just oh my.
None of this makes any sense to me. I'll be blunt. This would have made more sense to me if they said this is a reasonable regulation on the Second Amendment consistent with what the justices said in what they outlined above and what I covered here in this video. But by basically just going in an entirely different direction, they are denying the fact that the purchase process of firearms, of ammunition, is consistent and part of the possession right of the Second Amendment. That does not make sense to me. So in other words, they're saying, yeah, you know what? You've got a right to bear arms. You've got a right to possess weapons. But the government's burden on you to purchase those weapons, you don't have any rights relating to that. The Second Amendment doesn't protect that. That doesn't make any sense to me at all. And they kind of set you up for going in one direction. And then I don't know if they just, it was Friday afternoon when they were writing this decision or something. And they just said, good enough. Someone finish off the opinion and just go. Because it kind of has that just drawing suddenly to an end. It's a very brief decision. But I wanted to talk for a moment about some of the pros and cons, some of the goods and bads that come out of this. Because this is going to be incredibly important to watch the ongoing development of where this case, where this literature, where this jurisprudence goes now that we've got the U.S. Supreme Court Rahimi decision ruling against the Second Amendment in a lot of ways. So we're going to start with some of the negatives, some of the cons about this decision. One is that it's frankly a ridiculous decision by saying that the requirements and the burdens placed on you exercising your right, which you have to be able to purchase firearms in order to exercise your right, they're saying that this has nothing to do with the Second Amendment. It's not protected by the Second Amendment. That's ridiculous. Don't like that. Number two, I don't like the Rahimi quotes, most of them I covered here in this video, that are coming out to be used to, in essence, water down the 2A, even if they did not predicate their decision on those quotes. Just the same, you can see this lineage of all this anti-2A quotes being pulled from Heller, being pulled from Bruen, being highlighted and pulled from Rahimi. This is all coming down, and it's only going to be a matter of time until courts start basing their decisions on saying, yep, the Second Amendment allows it, look at all this. All right, so if you're confused about what possible positives could come out of this, it's because I didn't cover all this, just didn't have time to cover everything. So I'm summarizing it here. In this decision, the Ninth Circuit is forced to concede several key things. One, handguns are arms under the Second Amendment. There was a time when they absolutely would not have done that. So handguns are protected by the Second Amendment. Two, someone not in the National Guard, divorced from militia service, is protected by the Second Amendment. There was a time when they would not have said that. Now they are. Three, they conceded that you have a right to carry arms outside your home without some sort of special need. Recall that the Bruen decision struck down the Sullivan Law from 1911. That's the New York carry case, basically, that all the basically bad carry law across the nation was based on. The Supreme Court struck that down. That's at the heart of the Bruen decision, which among other things required that you have to have a special need to go and carry a firearm outside your home, and special need is basically code for virtually nothing will satisfy that. The Ninth Circuit agreed, nope, that's bad law. Don't need to do that. Maybe this is me trying to find a silver lining. In part it is, let's be clear and upfront about that fact, but if the Ninth Circuit Court of Appeals is agreeing on those three things, that would have been unimaginable 10, 15, 20 years ago. That would have been unimaginable probably 5 years ago. But here we are. It's important to celebrate our victories. It's important to celebrate our success because it's very easy to get drowned in the negativity, understandably so, given the strong forces and the headwinds that are arrayed against us. We have to keep up that fight. As always, I appreciate you sticking around this long. Don't forget to hit that like button, and we will be rewarding you with that ever popular quote of the day. This one comes from Greek thinker, writer, philosopher Epictetus. Always a fun one. Quote, "Wealth consists not in having great possessions, but in having few wants." Great to see you. Great to spend some time with you. And I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.